Okay, so I want to shift gears a bit because we've talked about definitions, and I want to just mention and refresh your memories about the reporting requirements, and then talk a bit about assessment, which I threatened, and a little bit about treatment today. We report because there is a mandate. The law says very specifically to us, and I will read you the language, but you've all heard it before, if I can find my glasses. We've already talked about who has to report, right? But we are supposed to report when a mandated reporter, of which all of you are one, has knowledge of or observed a child in his or her professional capacity or scope of employment, whom he or she knows or reasonably suspects has been the victim of child abuse. Notice, has knowledge of or observes. There are a couple of states that require that a child come before us. So if we were in Colorado or Pennsylvania, we would actually have to only do a report if we've literally seen the child. That's not the case in most states, including California. Okay? Actually, this is, I'll get you the actual section. It is 11167, I believe. Actually, it is 11166, not 11167. 11166A, except as provided elsewhere. A mandated reporter shall make a report to an agency specified in section da-da-da, whenever that reporter in his or her professional capacity, and so on. Okay, that's where the language is. 11166, okay? Sure. A number of questions were asked about professional capacity. Professional capacity or scope of employment, it's when you are either at your job or doing the job you've been assigned, or you are acting in a professional manner. So my teaching this class is in my professional capacity. Okay? I'm a licensed psychologist, so I'm a mandated reporter. If you came to me and said, I have a situation, da-da-da-da-da-da, generally the other person, that is you, are going to be responsible for the report, but if I have enough information, I might have to make that report too, unless the other person took it over. So hence I say to you, don't give me really specific detailed situations. Now, when I'm supervising here at school, when I'm doing my clinical and ethical course and I teach students and they come in and they talk about cases, I am a mandated reporter, as are they. So that's professional capacity. Similarly, if I am employed at the VA, okay, when I get to work and I get into my office and somebody gives me information about a child being abused, I must report that. But let's say you go out for lunch, Peter, and it's about 2 blocks away, and you're at a lunch counter, and you see a parent doing that, picking up the kid by the arm and whacking him, and it's really violent. You could, under our law and even our professional ethics code, turn around and leave and do nothing, okay? Because it's not within the scope of your employment, and it's not within your professional capacity. A little bit of jurisprudence or a little bit kind of history around this particular law may be helpful. There was a thing that was a particular law that was in place in colonial times in the United States and in England called misprision of a felony. Misprision of a felony was an act that basically said that if I see you engage in a felony and I'm a citizen, I have a duty to report it to the king. And if I fail to do so, I can be punished virtually as much as you could for actually committing the felony. What was that intended to do? That was intended to make everyone into proxy police. And so one of the first things that the 13 colonies did when they rebelled was to write out or get rid of misprision of a felony. And it doesn't exist in any of the constitutions of any of the states in the United States. We do not have misprision of a felony. So child abuse reporting and elder and dependent adult abuse reporting are some of the few statutes that run counter that idea that we are mandated to report things to the authorities. So our fundamental constitutional right is to turn around and walk the other way. That's your constitutional right. But you don't have to exercise it. You can do the opposite. So I encourage you to make those reports. But I want to make a distinction, and the law makes a clear distinction between, I guess maybe it's not constitutional, but it's clearly a right of ours. It makes a distinction between our professional roles and our personal ones. So you can think of it like if you're a parent, as you are, and you have a 4-year-old, and you see your partner go off on this 4-year-old, you would be a mandated reporter if it was not limited to your professional capacity or scope of employment. And that arguably could be a pretty significant intrusion into private life, particularly if it was one of those fence sitters, you know, where maybe it's emotional abuse. Well, maybe possibly is it willful infliction of mental suffering. So it puts you in the position in your own home of policing your partner. And perhaps she or he would not be able to police you except by an anonymous report. So you can see how the intent here was to draw some lines, but not limit us to reporting in our professional roles if we choose to report in a non-professional one. Okay? So it is odd. And you know, your sense of what the inconsistencies are is accurate. And history kind of at least gives some explanation, if not some relief, about why it is we have those rules. Now, a note about reasonable suspicion. The definition, please don't write this down, it's in the law, but the definition is absolutely mind-numbing. We must report when we have a reasonable suspicion. And a reasonable suspicion is defined as when it is objectively reasonable for a person to entertain such a suspicion, that is of child abuse, based on facts that could cause a reasonable person in like position, drawing when appropriate on his or her training and experience, to suspect child abuse. Another tautology. It's a tautological definition. It's reasonable suspicion when you think it's child abuse. So I like to kind of consider or think about the idea of reasonable suspicion as if you consider a continuum. I'm not going to try to draw this. I'll trip, I'm sure. A continuum of 0 evidence or data to 100%. So we have nothing versus we are completely and utterly sure, we're certain of the probability in this situation. In court, you'd have to prove for a crime what? Beyond a reasonable doubt. Very high level of proof, very high level of certainty. Some people have said 80%. I think of it as being 90 or 95% sure. The point, you know, the 0.05 level. We're talking really sure. If you're in civil court and you want to prove liability, you have to prove preponderance of the evidence, slightly more certain than not, only 50.1% sure. And to report child abuse, we're probably talking about only 15 to 25% sure. It's got to be based on some evidence, but it doesn't, and it can't be just a guess or a rumor or a bald accusation, but we don't have to even be sure as to the preponderance of the evidence. We just have to have a suspicion that's reasonable. If we do, we report. So I call it a very light trigger or a very low standard. And to put it in context, there's no way someone would be held responsible civilly on the basis of a reasonable suspicion. It would get thrown out of court. But for our purposes, we have to make a report when we have reasonable suspicion. It's a very light standard. There is no legal requirement that we inform the child or family. There is an ethical requirement that we let people know about the limits to confidentiality, and that we also remind them at the time that we have to make the report. There is I haven't gone on yet to immunity, and I'm going to have to move through that quickly, but there is a rule that says that we cannot, there's an interpretation by a number of attorneys, we cannot disclose to clients the actual form. We can verbally talk about it. We can even do a report arguably in the room with them there, but we should not and cannot disclose it to clients. And even appropriate to a subpoena, we should not send off, even in response to a valid subpoena with a waiver by the client, we should not send off a copy of the child abuse report, the official one. That should only come if there's a court order, because it is only supposed to be delivered to very specific categories of organizations. CPS, police, DA, that's about it. Maybe a couple of others, but not the client, and only if a court orders it. So you want to be sure to omit that, and you'll put a page in that's blank. Material could not be sent because it has legal protection or because of legal constraints. Something as simple as that. The written report must follow up. Now, if you take a look, most of you, I think, have used these. If not, you want to take a look. There is a new law, went into effect last year, that says that we're permitted, if phone call is not successful, we try the phone call, but we get a recorded message or something that says, We do not take these reports via phone. Please fax them to the following number. We are permitted to fax them, and we don't have to follow it up with 36 hours because we've already delivered the written report. Okay? So that just came into law. It's going to be phased out in 2009. They're checking to see how well this works. And the long story about how come this happened is not even worth going into. Suffice it to say, you can fax them, but first you have to try to call and document your attempt to make that phone call. You know, what happens when you have a 21-year-old client, now in college, who discusses oral copulations that she engaged in with a partner when she was under the age of 18? In California, it is not a mandatory report now unless there's currently a child at risk. Okay? So in that situation, voluntary behavior, maybe somewhat uncomfortable with it, you know, broke up with a partner, but this didn't have to do with somebody else who was a child and somebody who was necessarily had an interest in kids under the age of 18. These were two 17-year-olds. Okay? On the other hand, let's use a 35-year-old who says, you know, my uncle's like really kind of weird, and you end up having this conversation where the client discloses to you that she was sexually abused by the uncle, and she never told anyone. And she said, you know, but it's not a problem anymore. I don't live there. And she says, but you know, I'm kind of worried about my younger sister. She's just the same age I was when he started to basically, you know, harm me. Well, in that case, there's currently a minor at risk and a report would be required. No younger sister and no kind of relatively defined circumstance where the person would have access to minors, you don't report it. Okay? But this is, again, this is a judgment call. One of the pieces is what happens if this is a janitor in a school? Okay? You want to learn about the nature of the relationship. Perhaps it was one where he groomed this young woman and was really a pedophile, or it seems to be. Then I think you'd have to make a report. There's a whole class of kids who are at risk at that point. Okay? On the other hand, you say, well, he was a janitor for years. What's he doing now? Oh, I think he's in a nursing home. Okay? He had a stroke and he's now in a nursing home, and he doesn't talk much. And well, is there a current risk to children? No, that would not be a report. So you have somebody who, this is very troublesome with sex crimes when you're working in forensic situations where you're trying to do treatment of sex offenders, and they're admitting to you in the context of doing sex offender work that they've been engaged in numerous other sexual offenses, right? And the law doesn't say, well, just because you're working at Corcoran and you're working with sex offenders or at Atascadero, you're no longer a mandated reporter around kids who were sexually abused. You are. Kids still a minor, still a required report. So my belief would be it would be a report. Sometimes that gets dealt with by what the local district attorneys do. They'll say, report it to us as a district attorney, and we will not pursue other charges if these inmates are admitting to other types of abuse that they've done. But it depends on the agreements that they have. I believe that there's still reports to be made. What happens after a report? Typically, CPS makes that decision about whether they should pursue it or not. If they pursue it and investigate it, you saw about 28% of them for the year that we were looking at are substantiated. Of those, most get therapy, about 65%. So we report it, and they're getting the same services that they're already getting. So you can see how, in some ways, it's not as effective as one might want. If there's a significant enough situation, CPS may refer it on to the police, okay? And they want to get it prosecuted. They will not refer on, and the Attorney General for California has said that people should not be prosecuted for general neglect because it's so related to socioeconomic status. So they may have kids removed. They may, folks who were, as in Beth's case, who are not able to step up and care for a child may have the child in foster care, but they will not be criminally prosecuted. There are a range of alternatives, as you all know, and in terms of placing kids, what happens is that they try to, with intrafamilial abuse, start with placing kids, for example, with non-custodial parents or close kin for kinship care. The next step is, if that's not available, foster care, and finally residential or group home placement. If there's a significant enough situation, CPS may refer it on to the police, okay? And they want to get it prosecuted. They will not refer on, and the Attorney General for California has said that people should not be prosecuted for general neglect because it's so related to socioeconomic status. So they may have kids removed. They may, folks who are, as in Beth's case, who are not able to step up and care for a child may have the child in foster care, but they will not be criminally prosecuted. There are a range of alternatives, as you all know, and in terms of placing kids, what happens is that they try to, with intrafamilial abuse, start with placing kids, for example, with non-custodial parents or close kin for kinship care. The next step is, if that's not available, foster care, and finally residential or group home placement. But only about 14 to 18% of substantiated cases end up in foster care. That's not 14 to 18% of, that is, of the 28. It's the 28% is 100%, 14 to 18 of that. Okay, so it's a much smaller number.